Michelle, we heard from you first. Perhaps you want to lead us off with a few of your final thoughts.
Okay. Thank you, Hugh, for that great presentation. It was really good to get your perspective as well. I would just say when you're looking at the duty to defend, you want to look at the complaint. You want to consider make sure there are no undisputed facts, and if you have the opportunity to get extrinsic evidence, you should try to do so. On the settlement demands, you need to put the interest of the insured equal to your own, and remember that your obligation is to get the insured out of harm's way, and try to do your best to make a reasonable evaluation of that case, and have your adjusters be proactive in trying to resolve cases and get medical records, because oftentimes things go south when there are delays or a lack of diligence on a particular file. So those are my highlights.
Thank you so much, Michelle. Hugh, we then heard from yourself. Perhaps you want to close us out with a few of your final thoughts.
Yeah, I'd be happy to. Thanks, Michelle. That was great. This was a lot of fun. Two points here. One, I've hammered this. Corporate culture matters. Care about your insured. Try hard. The second thing, because I've sat in on some of these conversations, is don't, and I of course I know the defense bar really well in a small state like Connecticut, and don't let the echo chamber, and to put it kind of harshly, the mutual admiration society, don't let those conversations color your judgment too much. Try to be as rational and reasonable about the value of cases as possible, because those conversations between adjusters, among adjusters, sometimes there will be a comp adjuster on the line, but the liability adjuster and defense counsel, they can be mutually, there's the potential for mutually reinforcing unreasonableness. And, defense counsel, like, I got this. Well, remember, the defense counsel has a conflict of interest. He wants your business. He wants the insurance business, and he wants to sound tough, and he or she wants to sound like they really know, they're just gonna destroy this plaintiff. And I know so many defense counsel don't do that. They're reasonable, they're experienced, they're great. So this is not a knock on insurance defense counsel. But there can be an echo chamber and a mutual admiration society kind of approach to this, where Michelle mentioned one factor, which is just dead on, that insurance companies do have a tendency to think that there's going to be more comparative liability, and that just is not true. It's more of an all or nothing kind of thing. If a jury likes an insured, they're not going to fault them for not looking down at the sidewalk and seeing the crack. They're just not going to do that if they think that the defendant did something that was wrong. So comparative liability is a classic mistake. Just be careful with the investigation, and be aware that defense counsel wants to tell you what you want to hear. There's an inherent bias in those conversations, and be as rational as possible, and really pay attention to your investigation and everything that is as objective as possible. Make everything as objective as possible. That's my advice.